Hi, and good afternoon, everybody. Our apologies for being so late. We had some technical difficulties today with connections. Technical difficulties, it's always an interesting question. You say, well, what does that really mean? So basically, we use a third-party provider called Restream, and Restream allows us to stream live not only via LinkedIn, but other social channels as well. So we were having trouble with our Restream link. It looked like it was a quick fix, and it wound up taking a little bit longer than usual. So here we are. Today is Tuesday, January 21st. It is 1:15 p.m. A lot of great things happening. Certainly a lot of change. We're in a new year. It is a new year. We have a new president, of course, as well. So there's a lot of change. And we'll leave it for everybody else to make comments and decide on the benefits or detriments of that. But nevertheless, we are also involved with a certain lawsuit that has caught the attention of much media, much press, and that is the Blake Lively and Justin Baldoni lawsuits. So interestingly enough, this is not a very straightforward, direct, one and out lawsuit where one party's suing another and maybe there's some counterclaims. There's a lot of stuff flying around. So today, what I'm here to do is not so much to go into all of the facts and the details about what everybody's alleging in the claims, but to really focus on one particular lawsuit, the third one in time, which is Justin Baldoni's lawsuit against Blake Lively and Ryan Reynolds and related other parties, and to hone in on number one, the various claims that are made as to whether or not they may survive dismissal and whether or not they can proceed. And we'll actually unpack, the elements required to satisfy these claims, but also to tie this into a larger conversation about business and business law. Because believe it or not, while it's true claims for defamation are a First Amendment issue, everything overlaps because whenever you enter into a contract or an agreement, you're always agreeing to do something, which, by the way, might actually limit your rights that you otherwise would have. So, as an example, maybe there is a scenario where you normally would be allowed to say something and it wouldn't be considered defamatory, but maybe you contracted to agree not to say something. And for that reason, what governs your First Amendment right to speech or the contractual agreement that you entered into? So, we're going to have a discussion about that and we'll have some interesting back and forth on that topic. Okay, so where to begin? First off, for those of you that do not know, Blake Lively and Justin Baldoni recently worked on a film together. And the title of it, This Is Us, came out. The film came out not too long ago. It stars Blake Lively and Justin Baldoni. And it was turned into a film from a book. Justin Baldoni was to act as the primary producer, but Sony was involved, et cetera, et cetera. And ironically, it's sort of a romantic comedy, but then it takes a hit and twist where Justin Baldoni's character gets involved with Blake Lively's, and he winds up being abusive. And it's meant to raise awareness of abuse in relationships, in addition to just showcasing general takeaways of relationships. Otherwise, now after the film came out, it did very well. It grossed hundreds of millions of dollars, from what I understand. Certain allegations came out concerning what was taking place on set and during the filming. Now, Blake Lively is the first one to take public concerns, and what she wound up doing was she filed in California in December of 2024 a claim against Baldoni, alleging sexual harassment and issues concerning working conditions. And the primary issue that or takeaway was that Baldoni was supposedly involved with making claims and comments that involved her feeling uncomfortable, and that extended into sexual scenes that were to be filmed for the movie. Thereafter, in January of 2025, I believe just early January, it could have been late December, but the New York Times ran a piece concerning this lawsuit, and there were dialogues and conversations had with Lively with respect to what Baldoni had purportedly done. Baldoni then, in turn, winds up suing the New York Times, alleging claims for defamation against the Times, and ultimately the idea there being that they're reporting and publishing information that simply isn't true to third parties. Thereafter, Baldoni then files a lawsuit in New York, in the Southern District, against Blake Lively, Ron Reynolds, and others. And ultimately, what he alleges is that there was a lot of coercion, there was a lot of uncouth acts. And in fact, Blake Lively's entire lawsuit alleging sexual discrimination had a prerequisite. And leading up to the lawsuit, Miss Lively herself was the one actually causing harm to Baldoni, because she essentially demanded that there were changes to the written script that be attributed to her and Ryan Reynolds, that she insisted upon getting certain production credits, even though Baldoni basically said you're not really entitled to those, but he did these things. And there was always this threat that if he didn't do exactly what they demanded because they had power, that they essentially were going to ruin his reputation and destroy his career. Now, we are not taking sides on what actually took place to go through the factual analysis, frankly, something that we here haven't done fully and we won't have done today. But what we want to do is focus on the various causes of action that Mr. Baldoni wound up alleging in the New York Southern District lawsuit against Blake Lively and Ryan Reynolds. So this is not concerning the case of Baldoni versus the New York Times. This is not concerning Blake Lively's case against Justin Baldoni. Those may be topics for a future LinkedIn Live if we decide to proceed in that direction. So understanding now the crux of what's taken place, in the New York action, there are a number of different causes of action, and they're very interestingly pled. Usually in cases like this, what happens is the plaintiff files their claims. Then the defense is given the opportunity to ultimately move to dismiss. In other words, to say that even if taken as true, it's a motion to dismiss. It's a 12b6 in federal court motion to dismiss the claims for failure to state a cause of action. And that's generally what a defendant will do at the beginning of any case like this to see if they can knock out all of the claims or some of the claims. Oftentimes, a lot of defamation claims can be dismissed simply because there's not enough evidence. With even taking what the plaintiff alleges to be true, you simply cannot satisfy all of the elements that would be required to actually win at trial or to win on a summary judgment motion. So in the Baldoni case, we'll discuss what the various causes of action are, how they sort of tie into, the underlying facts, and then we'll have a brief discussion of whether or not we believe that these claims would survive a motion to dismiss, which again does not mean that survival does not mean that the plaintiff will win the case, but it's just whether or not the claims will be able to continue into the discovery phase, where documents are exchanged, more emails, text, correspondence, third parties, witnesses will be subpoenaed, their testimony will be garnered, and the parties themselves will be deposed. And if we all recall and remember everything that took place with Johnny Depp, you recall that there were depositions that were recorded, et cetera, et cetera. So moving onward, for the New York action, the first cause of action that Baldoni alleges is a claim for civil extortion. Now, this is interesting because Baldoni's whole kind of theory hinges upon this idea that I was coerced and forced into doing things like giving production credits, making changes to the script, being forced to watch the opening in a basement, et cetera, because I was told that if I didn't do what you demanded, then I would be destroyed and crushed. Now, the Lively team has a document where there's about 17 points, where it rises to 17 pages, where Baldoni's signing off and acknowledging all the wrongdoing purportedly that he had done and the changes that he was going to allow to be made, on the set. And Lively has used this to prove that there was sexual harassment taking place. Baldoni's position on that is that this was all part of a coerced nature. He was forced even into signing that document. He was coerced into it. So in New York, it's important to say that there is no civil claim for extortion. You do not have a right as a civil plaintiff to come into court in New York and allege extortion. If there is extortion, you can proceed potentially with filing a criminal complaint. You could go to the district attorney's office and make your case. And if the district attorney decides to take a case, that would be a criminal case which they could pursue. So here, in this instance, what we have is the plaintiff alleging extortion under California law, and that's how Baldoni tries to get around the limitations on civil extortion's non-existence in New York. To prove a claim for extortion under California law, the defendant essentially, in this case Lively, Lively and Reynolds, must have threatened Baldoni to obtain money, property, or services. The defense must have known that the threat was wrong or unlawful, and the plaintiff must have given in to the threat of giving over or handing over money, property, or services as demanded. Now, what's interesting here is that we have a sense of how Baldoni could set forth an argument that would allow him to survive a motion to dismiss, because he's already seemingly made these claims that he had to provide stuff like production credits or making significant changes to the script um, based on threats. And since he gave in to this threat, one could argue that that alone could set him up for the potential to win on an extortion claim. Now, again, he would still need to prove at trial that he actually was extorted, because we don't know what the truth is right now. However, the other interesting caveat here is that the plaintiffs are trying to use California law, and there's a catch-22 here. If the nexus is New York, and the choice of law generally when you bring a New York case is New York law, absent a contract that states that another state's laws will apply, the default then is to proceed with applying New York law. After all, New York judges are most familiar with New York law, and New York judges' whole position is that if you're going to seek a case or seek a resolution before our forum, the case should be adjudicated in conjunction or in accordance with our actual laws. So it's interesting to note that in this instance, there's a catch-22. If you're the plaintiff, if I'm the defense, you're going to argue that California law absolutely should not apply. And for that reason, New York does not recognize a valid cause of action sounding in extortion. Therefore, the claim for extortion must be dismissed. That will, and that's a jurisdictional analysis that will have to be done, whether there's enough, just any justification really whatsoever to apply California law. Now, if you're the plaintiff, you may have a rebuke or a rebuttal, I should say, concerning that argument. And ultimately, what you would want to show is that there's enough connection to the state of California and New York to allow for this California statute or the California law to be able to be utilized in the New York court system. And that's a really fine line. And that's a hard tightrope to walk, because the second a judge is convinced that the California laws should apply in New York, it begs the question to say, well, why is this case not being heard in California? In which case, the plaintiff will have to make arguments that there's also enough ties to New York. Maybe the plaintiff's reputation was damaged more in New York. Maybe the plaintiff is residing in New York and has spent more time there and is suffering ridicule in New York, or financial harm more so in New York. But it's a tightrope that's going to be hard to walk. So my ultimate estimate or guess is that this claim for extortion may very well be dismissed. Next, you have a claim for defamation. Now, defamation is really the ultimate focal point of really lawsuits number 2 and 3 against the New York Times and against Blake Lively. So, of course, Justin Baldoni's whole idea is that this whole argument of sexual harassment, all of your claims, you making me sign these documents, none of that's true. But when you file a lawsuit, generally you have immunity. There is a high level of immunity that a plaintiff has to say whatever they want in a publicly filed document. Now, of course, there are limitations, and if it's so egregious what was said in a complaint that's filed in court, then there could be potential repercussions. But generally speaking, you have immunity when you're a plaintiff to file and state what you wish without concerns over a claim for defamation. And this makes sense generally, because the idea is that we want people to feel safe to come forward and not have to worry about retaliation. Of course, this entire case and this whole saga really is claims of retaliation by each side. And it's sort of a public relations mess that's now taking place in the public light, which seems to be what the parties at the end of the day have chosen to do. So, focusing on defamation, how do we establish a claim for defamation? Well, the elements that one needs to establish to prove or showcase a claim for defamation are as follows. And I should confirm and say, if you're reading about slander versus libel, what's the difference? Is it defamation? What are they? Libel is written defamation. Slander is oral defamation. So if it's written down, it's libel. If it's spoken, it's slander. And they're both defamation. So to prove a claim for defamation, the statement that's made must be demonstrated that it's false. So a false statement is made by the defendant, and then that needs to be publicized to a third party. So you have a material false statement that has to be shown that it's absolutely false, it needs to be published to a third party. So in other words, if I'm sitting in a room alone and I decide to say something to the effect of, well, John Doe stole money and he's a business owner and he stole money. If I know that to be false, but I say it to myself, nobody has a claim for defamation against me. However, if I call up Regina and I say, "Hi, Regina, did you know John Doe stole money?" And the reality is that there's no truth to it at all, and I had no reasonable basis to believe that, well, I might be held liable for defamation. But so the idea is that it's a false statement, a material false statement that's shown to be false, that's publicized to a third party, that identifies the plaintiff. So, in other words, I'm talking about John Doe. I'm not just saying, well, somebody in the universe stole money. I'm making it clear that John Doe is the one that stole the money. Then you have a false statement that's publicized to a third party and specifically identifies the plaintiff, and then there needs to be harm to the reputation. Now, let's say, for example, that my false statement is innocuous. John Doe is a business owner and he really likes flowers, or John Doe purchases hundreds of flowers per year. Well, I've identified John Doe. I've publicized this to Regina on my phone call. It's a false statement, but is it really going to harm his reputation? Probably not. The damages need to be there, and in that instance, they likely are. Now, you could go into a million different nuances, which law students will have a great time with, going back and forth as to the whether or not that could actually be considered to have caused harm. But generally speaking, it likely doesn't. The final step you have to show is fault. So now this is where it gets really interesting. When you're dealing with private individuals, the defendant in the case must have acted with at least some level of fault, which can be considered negligent for private figures. So if I had a good reason to believe, for example, that John Doe stole money, maybe I was given this information by a credible CPA for one reason or another. Maybe there was a bank statement that I took note of. And if I had a reasonable basis to believe that this was true, even if it wasn't, unless I'm negligent, so unless a reasonable person would never have thought what I thought, then there's no defamation. But if a reasonable person in my particular instance would have said, it's so clear that the information given to you was not accurate, then there's likely fault attributable to you and or to me, and therefore I could potentially be found liable for defamation. But now let's make this a little more interesting. There is a separate rule that applies to public figures, such as a Justin Baldoni, or such as politicians, such as those in the public light, in the limelight. And the standard is actually heightened when it comes to fault. And it's not just a reasonableness standard that, well, if I thought it was reasonable and a reasonable person would have thought it, then I'm off the hook. What the actual scenario is that the defendant has to actually act with actual malice, meaning even if it wasn't reasonable for them to publish what they did to that third party, unless they blatantly knew it was false or acted with a reckless disregard for the truth. So they knew it was false, or they acted with a complete reckless disregard. They didn't check any facts. They didn't do anything. Then they can't be held liable. So the plaintiff has this heightened burden of showing that a defendant, in this case, Blake Lively, acted with actual malice. And that's really important because imagine a situation where, even going back to the situation about saying that, well, I thought it was reasonable based on, I saw, I don't know, my nephew wrote something with a crayon on a piece of paper and said that John Doe stole money. So I thought, so I told Regina that John Doe stole money, and I identified John Doe, and he's now actually had reputational harm. But because I saw it in writing on a piece of paper, and it was my nephew, and my nephew is sort of involved in the business world, I thought that it was reasonable. And if it were determined that a reasonable person would have agreed, fine. Then, you know what? Or then you run into this situation where there could potentially be found that there was fault. Even if I thought it was reasonable, but if another person wouldn't, then maybe there's fault. But in the scenario, if this is a public figure, I'm probably not going to be found liable because I have to absolutely know, for the most part, that the claim is false for me to be found liable. Now, if I act completely recklessly, then I can be found liable too. So in this instance, it's an interesting scenario because here, what's very clear is a lot of the defamation seems to arise out of what was said to the New York Times. So if Blake Lively is the one making claims that she was sexually harassed, as an example, um, and it turned out to be false, well, she's going to know whether or not her statements are true or not, right? So the idea is that that intent, whether or not it's true or false, she clearly would know. And because she clearly would know, there is a chance that she could be found liable for defamation, even with the heightened increased actual malice standard in this situation, because she's going to be clearly the one to either know whether or not the claim is false or not. So she would be acting intentionally if she knew she was never sexually harassed, but she claimed that she was. Now, we don't know what's going to happen there. But since this is a factual situation, and since there's enough in the complaint to hit all of these potential elements, the false statement that's published to a third party that identifies the plaintiff, in this case, Justin Baldoni, that he suffered reputational harm, and that she knows it's false, or she either knows it's false or she doesn't. If Justin Baldoni can establish this, he could win on his claim for defamation. That doesn't mean that he will. So if the defense moves for a motion to dismiss, my guess is the claim for defamation will survive. We'll move into the discovery phase. We'll likely have a lot of deposition testimony, third-party deposition testimony, document and discovery demands, interrogatories will be with questions will be sent along, and this matter will continue on. And of course, based upon what the facts show and what the testimony shows, we'll get a better sense somewhere down the road whether or not the defamation claim is truly viable or not. Now, the third cause of action is an invasion of privacy, a claim for invasion of privacy. So this is once again very interesting. New York has a very limited scope with respect to a claim in a civil claim for invasion of privacy. This usually has to deal with an individual or a company that basically takes somebody's likeness and is advertising that likeness for their gain. So imagine somebody has a chocolate bar brand and they take Taylor Swift's face and her name and they put it on there and they start advertising and say, this is Taylor Swift's chocolate, or Taylor Swift chocolate is the best chocolate, and there's a picture of her. Well, they're now profiteering off of Taylor Swift's likeness and getting the benefits of that. So that would be a claim for invasion of privacy, could proceed with other claims tied in as well. However, in this scenario, Justin Baldoni is essentially trying to allege an invasion of privacy claim by saying that the invasion occurred when Blake Lively and others published or took emails, text correspondence between them and submitted them to third parties, the New York Times, etc. That doesn't fly in New York. However, once again, the plaintiffs have tried to utilize this California constitutional protection of invasion of privacy and insert it into the New York case. So the same analysis is going to happen. Which forms law should apply? If we're in New York, there's a heavy burden to suggest that the New York law should apply, not the California law. If the New York law does apply, this claim will be dismissed. If the California law, if it was potent enough that it could survive and stay here, then there's a chance that it could survive. Moving on from there, then the rest of the claims are a bit interesting because it seems like they're more oriented with what must be California claims. So, for example, we see claims sounding in negligent interference with contractual relations and intentional interference with economic advantage, et cetera, et cetera. New York courts also don't recognize claims that are stylized likeness, but what they're essentially alleging is a tortious interference with contract. And through that lens, it looks like Justin Baldoni is saying that, I believe in this case, it was Blake Lively's husband, Ryan Reynolds. They were trying to interfere with Justin Baldoni's producers or PR company, I believe it was a PR company, I should say, and to try and get them to drop him as a client. If that's true, a claim for tortious interference of contract where a third party is aware that there's a business relationship between two parties and they intentionally interfere with it, that could be a cause of action that could survive dismissal. The way that this is pled right now, I don't think survives, but I do believe that the courts ultimately will grant the plaintiff an opportunity to re-allege or to restyle the way that these claims are being set forth. So there you have it. I don't know how helpful that is overall concerning the facts of what's taken place, but hopefully now you have a bit of a better idea of what it is that Baldoni is trying to allege and claim in the New York courts, and a better idea of what might survive a motion to dismiss and what might not. Keep in mind, surviving a motion to dismiss is not, there's no culpability there. It does not attribute any guilt. All that does is allow the case to continue on to the discovery phase. Now, let's apply this to a business law situation because there's some overlaps that I think would apply specifically with the work that we do. And of course, we deal with defamation and claims arising out of defamation, but oftentimes our contracts and agreements also are strictly on point with this topic. So, as an example, when we're entering into agreements, whether it's an employer and an employee relationship, whether it's a third party vendor who is agreeing to perform services, often you'll have a contract. And in those contracts, or even if it's a settlement agreement after a dispute, you're going to have a set of provisions in any arrangement and agreements that actually touch upon some of these things. So, for example, Justin Baldoni in this instance has alleged an invasion of privacy. He is claiming that his private correspondence with Blake Lively or correspondence concerning the film were disclosed to third parties. Now, what would be a way to avoid an outcome like that? You could, and this is, I'm applying this now to a business sense, business on business. I'm not focusing and applying it or attributing it specifically to this case, just so we're clear. But you have two businesses, you have an arrangement. One party is going to be communicating with a lot of sensitive and confidential information. What you do is, as part of any agreement, you make sure that there is a confidentiality clause or a non-disclosure provision. Further, you could also make clear that all trade secrets or anything that has to do with the core of the business, so think in the Baldoni case, the core of what they're discussing, the production of the film, that all is considered some sort of secret or is subject to confidentiality. That would be a way to have leverage when somebody is considering disclosing information. They're going to think twice about it. Well, great. What else could you do? Well, you could also, we're dealing with a scenario where a lot of bad things were said, right? A lot of information was disclosed publicly that was negative and in fact potentially arises to defamation if it can be shown that the information relayed harmed everybody's reputation. And we'll see, or harmed the plaintiff's reputation. We'll see if truly that's what has taken place. Notwithstanding that, oftentimes in agreements that we're involved with, we deal with non-disparagement provisions. Non-disparagement provisions are strict clauses in a contract that make clear that the one party cannot speak poorly or publicize anything negative about the other party. So a non-disparagement clause is actually more restrictive than a claim for defamation, because defamation is focused on whether or not false statements were made that weren't true. And remember, in a defamation case, you have defenses. If you can have a defense of truth, that's a defense. So in other words, you may be saying that I iterated this false statement of material fact, but guess what? It wasn't false. It was true. So that's number one. And number two, beyond that, you can also say that, well, I wasn't making a statement of fact. It was an opinion. So if I say that Joe Smith has a big head, well, and then Joe Smith loses a lot of business because people think it's hilarious and a meme goes around online, guess what? That's not defamatory because, well, I take that back. Let me put it through another lens. I think that he's got a big ego, right? Or he has a big ego, and that's the problem I have with him. That's your opinion that he's got a big ego. So that would be a defense to one of these claims. But when you're dealing with a disparagement clause, it can be very restrictive, such that if I even published anything that was detrimental or sounded negative or disparaging concerning the other party to the agreements, I could be held liable for violating the agreement. So we've touched upon a confidentiality clause. We've touched upon a non-disparagement provision, which you'll see in many settlements. You'll also see that in many employment agreements and many agreements between different parties. And now let's make it a little more interesting. You could say, okay, well, what would my rights and remedies be if there's a violation of this confidentiality or if there's a violation of the non-disparagement? Because guess what? Somebody could still do it. And then let's say we sue. What would our relief be? Well, that's true. Somebody could still do it, even if it's contracted to, even if you've reached a contractual arrangement. However, the benefits of what you can do is not only can you seek an injunction to say that, hey, they violated these provisions, but if you add a third provision called a liquidated damages provision that specifically says that for each violation of either the confidentiality provision or the non-disparagement provision, for each violation of either of those, the defendant will have to pay a fee. Let's say a liquidated damage of $15,000, $100,000 per occurrence. Then guess what? Not only can you run into court, obtain an injunction, allege that they disparaged you, they violated the agreement, maybe it's also defamation, but you can now say to the court, not only the specific damages that we want, because these damages tend to be unclear exactly what the monetary harm is, we have a contract that states for each occurrence of defamation, disparagement, or breach of the confidentiality, we're entitled to a specific amount of damages. And that is a fantastic way to put yourself in a position where you will be able to recover from a monetary perspective through a contractual agreement. So there you have it. That's today's LinkedIn Live. I hope that this was valuable. I hope that you saw some benefits or got an idea of a little bit about what's going on with the Baldoni case, a little bit about what claims, if any, are likely to succeed on a motion to dismiss. And then we talked a little bit about how we could tie in some of these issues, how you could actually resolve them or preempt them through a business relationship via contract. So once again, my name is Ross Pitkoff from the Pitkoff Law Group. We are your family-first, business-oriented law firm located in New York City. We also have offices where you can book an appointment by appointment only in Boca Raton, Florida, and also in Jersey City, New Jersey. And we involve ourselves in all type of commercial litigation, business and partnership disputes, and we provide company counsel and representation. I hope everybody has a great Tuesday, and I look forward to seeing everybody.